I've just concluded my visits with the free men. That's what I call them.
Your Prime Minister fire you. Your Prime Minister fire you. Go outside. Go outside. Thank you.
When the former Speaker was forced to resign as a result of an Integrity Commission investigation, the move to replace her with the wife of the Prime Minister, so that the head of Parliament is now the spouse of the head of government, really does not sit well with the tradition that the Speaker must act independently of the government of the day. The Speaker is intended to be independent and must act independently of the government of the day. That is the tradition. That is the tradition. The failure, Mr. Speaker.
Members.
The failure to identify the so-called illicit 6 MPs.
Your Prime Minister fire you. Go outside. Your Prime Minister fire you. Go outside. Your Prime Minister fire you. Your Prime Minister fire you. Go outside. Go outside. Thank you.
Period. All I can say to him, and I would have said it to him if we were still in the house, all I can say, if I were in your position, I would take with myself and hand over to someone else who is not compromised.
Yes.
Jamaica's iconic global track superstar, the Honorable Usain Bolt, and many other innocent investors were carried down in the scandalous SSL fiasco. And we can't hear anything about charges being brought against the culprits. I have been told that the DPP's office is dragging their feet when there are a number of people that the Financial Investigations Division are seeking to bring charges against. In fact, in August last year, the Gleaner carried a report that from the FID that there were several persons that they were intending to move against with charges. That report is no longer on the Gleaner website, but I am told that the DPP's office is dragging their feet on this. The Kroll forensic report, which has cost taxpayers millions of dollars, was delivered to the government months ago. It must be released to the public so we can see what the findings are. Jamaica will not accept a...
So I'm Isat Buchanan, attorney at law, attorneys for Adidja Palmer, Sean Campbell and others. The Privy Council in the United Kingdom have made their ruling or their judgment quashing the conviction of the men. What does that mean? Well, it means that they no longer have a life sentence over their head and they're no longer convicts. And that is very important. They are currently detained at the Tower Street Correctional Facility, where I'm now located. That's aka GP. The court in Jamaica, the Court of Appeal in Jamaica, are going to be responsible for determining whether or not the men will have a retrial or they'll be set free. We are awaiting the last document or the important document from the Privy Council signed by the King, which gives effect to the judgment that they handed down on March 14th. So people have to just be patient and know that justice rushed is justice crushed in this particular situation, given the success of the appeal. All right, I've just concluded my visits with the free men, that's what I call them, and they are elated, they're excited, they feel a weight lifted off their shoulders. They no longer have that life sentence, and they're looking forward to their day in court where they will be set free. And the mantra is God on time.
Learned attorney.
Yes.
This morning I was appalled when I heard the pronouncements from the Director of Public Prosecution. The Director of Public Prosecution basically has admitted that time and time again the jury has been tampered with, and she has proceeded with such. I can't sit and come to the reality that a lot of innocent people, a lot of people could be put away and they're innocent, and this is the situation where a jury is tampered with. And the Director of Public Prosecution's office has decided to proceed with it. What's your take on that?
Well, here's the thing. The press release speaks for itself. The defense certainly stands united in taking the position that, listen, we're not trying any case in the media. There's no need for clarifications after the fact, because this is why context matters. If one looks at the judgment of the Privy Council, everything that you need to know and everything is in the judgment in relation to the facts that are before the court, or before that was before the court, and what the Privy Council pronounced on. The next thing I will say is, in an adversarial system that we have, the criminal justice system is an adversarial system. What people must understand is that the defense, as creatures at the defense bar, is there to defend, albeit being an officer of the court. They find themselves defending. Similarly, the prosecution, they too, as creatures at the bar, are going to prosecute. It is in their nature to prosecute. What is clear in terms of the ethics, the ethical implications, is that defense win cases, prosecutions do justice. So where emotions are concerned, one can strip the reality of the emotions and think we must not be blindsided or distracted that what has happened is a monumental decision that has implications for the common man. Take out who these popular defendants are. That's how I'm going to refer to them as. And know that your brother, your sister, your father, somebody who is not of means, is expected to be cloaked in the presumption of innocence, is supposed to have what is known as fair trial. So when somebody says that the Constitution says has been, is being, and is likely to breach the constitutional rights, we must give effect to the Constitution and understand that when Justice Sykes speaks about the importance of the Constitution in needs and the way forward in how we interpret the Constitution, no one should be allowed to breach constitutional rights and treat it as if it is not a breach. This is generally. So to have the public put on their critical thinking mind.
Yes.
What is it that we must accept as a people? Is that if we want better, if we hope to one day get to Singapore, there are just certain things we are not supposed to allow to happen. No, we are guided as attorneys by the canons, the ethical canons, and it is important to note that those canons, one
Yes.
refers to canon G for defense attorneys in terms of how they are to conduct themselves as officers of the court, and likewise one refers to canon H when it comes to attorneys on the prosecutor side and how their ethical implications and how they're to conduct themselves. What is clear though is the discourse is unfair to the gentlemen, because the jury pool, we expect, one of the things where the Magna Carta says is you're to be tried by a jury of your peers. Codified in the Constitution of Jamaica is that you have a fair trial within reasonable time by your peers, and an impartial jury, a fair and impartial jury. That's the hallmark of a fair trial. One cannot get that when we have these public discourses and have the village lawyers start to make implications against against the and influence the village judges before they get into the court. It has to stop, because this is something where if the Constitution has any effect, and I can tell you there's only one done in this country, and it's the Constitution. So whether you're on the green side, on the orange side, or you're on the justice side, or you have big job, or you're homeless, the Constitution is the done of all dones. And if you're not acting in accordance with the Constitution, you are a degenerate. You cannot do that, and we must never allow anybody, whoever they are, to breach the rights of the citizen. This is generally. But similarly, no, just let me make this one point. Similarly, one cannot allow the platforms, you included, we must not use our platforms to paint narratives, mislead the public, misguide the public, for instance, even by inference. So an article was published in the paper, and there's a conversation about jury tampering. Well, I'm going to make clear to you that a reading of the Privy Council judgment, one of the key reasons why the conviction was quashed is because not one iota of evidence was presented anywhere that the men, all four of them, had anything to do with jury tampering. And if one goes back to my presentation before the Apex Court at the Privy Council, in my advocacy and plea to have that conviction quashed, I made it clear we must never attempt to speculate, because if the public thinks that it is the defendants who are responsible for tampering with the jury, it can equally be put at the feet of the prosecution. And I am saying the basis of the press release is to say we are not to do that. We have to respect the justice process. We have the judicial process, and this went through an appeal that took 14 years to get there, 13 years to get there, close to 13 years to have the matter concluded. The Constitution speaks about delay, and we have all these things to be ventilated. Can the public just step back a bit and allow the justice system to work? It works. I've been saying this all the time. So you can do what you want at first instance.
So you're asking your call and the call from the attorneys representing the men whose convictions have been is for us to lay back for a while and let natural justice take its course.
I'm gonna do more than that, and then you can throw big stone at me.
What you want us to do?
Just listen. Do not disrespect the office of the DPP.
But
no, just hear me out. Just hear me out. If you're on the defense side, don't be disrespectful, don't be rude. Don't put out defamatory accusations that you cannot prove. Just simply do not do that. The facts speak for themselves. The judgment speaks. Listen out, the judgment speaks for itself. So if at any time you are disgusted, it is what the judgment says. Nobody have to add flair, and nobody have to put context or angles or anything to it to have anybody say anything. I'm just asking for the purpose of what is happening. Nobody don't need to disrespect anybody. Certainly on behalf of my clients and myself, we don't need no advocates to get into what is called the trenches. The defense deal with law. Let those who dig trenches and gamble and do whatever they have to do, let them do it. But we are not.
So you're asking for the personal attacks on the DPP to stop.
To stop and make it clear that not one person on the defense side has made any attack. And we must put things in context. That
because the DPP is saying that there is a campaign of misrepresentation.
Well,
out there, and you're saying that it's not the defense.
I'm going to tell you something. It's only one misrepresentation ever win 8 Grammys. And it's the misrepresentation and miseducation of Lauryn Hill. And that was a good album. But anybody, if you want to fact check, look at the Privy Council's ruling. And if at any time somebody don't understand, I am prepared to sit for 10 hours and read from the top of the judgment to the end of the judgment so that people understand that context matters. I am very happy to say that when this trial took place, I was not a member of the bar. So I was not at the court of first instance. And so
my apologies. Repeat that. Repeat that.
I was not a member of the bar and I was not a part of the trial. But what I can say is when I went to the University of the West Indies and I was taught about constitutional rights and the importance of the charter, I've been on this platform and I spoke before as to how young the charter is and how
12 years old.
Yes?
12 years old.
Yes. As old as this trial, and say that the constitutional rights is for all. So I don't care if you dislike Mr. Palmer or any of the other men that are a part of this case. What you need to know is that when the Privy Council made its decision, it made its decision because the effect of the breach of the fair trial rights and the integrity of the justice system, the judicial, the jury system, the Magna Carta, the importance of that would have affected England so much so that it cannot be said that a man is only free when he breathes the air in England. And so if the guilty man, the purpose of it is so a fair trial is that when you are adjudicated guilty, is that you do it. We don't deal with feelings. So all people who like to talk about feelings and who from mama want ball and who want do this and pretend like say people are upstanding. We must appreciate that it is the system that we are protecting. And when the apex court has even said, we sympathize with the judge. We sympathize and we make it clear that if there are problems with the law, it is upon the parliament to fix it. But what is clear that there is case law that's guided, and the case law says a man cannot benefit from tampering with the jury. Tampering can only take place from the outside of the jury room. So when there's an infestation in the middle, inside the jury, and you are aware of it, you are to cut that infestation. Failure to do so, you have ratified, you have become an accessory, and it is a most unfortunate act, and it's not something that we must pretend like it never happened. Those are the facts.
But then I want to ask you the next question now, Isat. I saw that the DPP is now talking about a jury act being amended.
Yes.
Can you explain to the common man why is she now rushing to amend the jury act?
So this is what people must understand.
Yes, explain. Context matters. Explain it.
Context matters. You're a learned DPP, notwithstanding how anybody feels about her. She has years of experience, and make no mistake, she knows the law. many legislations which have been put forward, she has been a part of ensuring that where there are gaps in the law, she says my office cannot do what they're supposed to do. I need some assistance. That is why the jury has been reduced from the nice 12 to about 7 now. And
Wow.
questions and implications come from that, and that will be ventilated for the public to understand the significance of the whittling away of the jury system under that type of thing. What I will say is, and don't be shocked, but I agree with her that we must advance our laws so that people where the parliamentarians are lazy and the people who are responsible for updating the laws,
Yes.
we must wait until a dog bites a baby. We say, oh, we need to change $100 fine. It must be updated. That is a part of improving the jurisprudence in Jamaica. So we can be proud of the laws because they work. So I join with the DPP that the act must be updated.
So what does the present act reflect? What
the
can
present act says we can't go below 10. And if we go below 10, the judge has a duty to respect the Constitution, to uphold fair trials. And if it reach 10, if he has to discharge the 11 for whatever reason and reach 10, that's the end of the matter. Don't matter what day of the trial, don't matter how much money spent, if you cannot use the mechanism such as a warning with particular, if you can't protect from bias, impartiality, influence, corruption, poison, all of these things, gambling, I'm using all of them, then you you are mandated to discharge regardless of the advice given. And those who give advice, who are creatures of the constitutions, when giving the advice, you must take into account. This is not gambling. It's not a party shop. It's not cash pot you're buying. It's people's life. And so moving from that, in England, the jury, if it was reduced to 10, the trial could continue. We need to get there. Also, if it is that it is found that the entire jury is corrupted by, let me be clear on this because the case law is clear, by the actions of the defendant, then the judge discharge the jury and continue with trial alone. Because a man must not benefit from manufacturing or being the author of corruption. Or author of influence. We want that for our justice system. And similarly, while this legislation is being amended, because I would have heard or seen in the newspaper where our justice minister says, yeah, I'm going to just amend it. And just amend it quick, cut and paste. We have a little bit more conversation to have in terms of the implications. Because we must remember, we are in a place where a jury system, the right to the trial by jury, protected by the Magna Carta, jury of your peers, still remains the choice for people.